In the last 16 months, the Seventh Circuit has handed down a series of 3 opinions restricting the ability of debtors in Chapter 13 to retain estate property in the Chapter 13 estate after confirmation. All of these decisions, all 3, were written by Circuit Judge Frank Easterbrook. The most recent decision came down this week, and I have written about it in my column on ABI's website on July the 9th. These decisions raise a very interesting question. Simply, it's this. May courts limit the exercise of a debtor's apparent right under Section 1322 of the Bankruptcy Code to exercise an option that is provided to them by the statute in terms of retention of property in the estate after confirmation? Also, by the way, the national form of a Chapter 13 plan has a check the box where the debtor can elect to retain property in the estate after confirmation. For me, these cases all raise the question of whether courts may establish limits or restrictions on the exercise of a right that is evidently granted by the Bankruptcy Code. Everyone who is involved in Chapter 13 practice, I believe, needs to read all 3 of these decisions and decide for yourself, is this something that courts are entitled to do? Also, I think the big question for me is this: will any other circuits follow suit, and will we eventually have a split of circuits? As those of you who read my column know, I often end my column with what we call observations. And today I want to make an observation, but not about bankruptcy law, but rather about, I guess you could call it, the inconvenience of the lockdown in view of coronavirus. Specifically, in my case, I have not been able to have a haircut for almost 6 months. I have already passed through the stage where I look like Benjamin Franklin, and I am now looking as though I am a, shall we say, clone between Albert Einstein and Clarabelle the Clown. You can't really see it now because the wind hasn't kicked up, but if it were, my hair would be all over the place, practically down to my shoulders. However, I believe that my salvation will occur in 2 months. And in that respect, I don't mean that I'm going to be able to have a haircut because I think I either won't or can't, but rather, another 2 months from now, I'm going to be able to put my hair up in a ponytail, problem solved. Which goes to show that one way or another, there is some means for avoiding the inconvenience of the lockdown in terms of preserving our personal safety. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting in the world of bankruptcy. Until then, be well, stay safe, stay home, and God bless you all. Good day.